Good morning. Thank you, everyone, for joining us today for our fifth and final family engagement workshop for the year of 2022. My name is Sonia Samaniego, and I am the Family Engagement Coordinator. Today, we are joined by a couple of representatives. We actually have Amanda Glass here from the Arizona Center for Disability Law. And later we might have another representative joining us from Raising Special Kids. But we are here to help us learn about the importance of advocating for deaf, hard of hearing, and deaf-blind children. Really just want you to know about some of the main questions or areas that are of concern for parents. Lots of questions come about, lots of things to think about. And so we really want to cover those main areas in today's workshop. Before we get started, I just want to make sure that I cover a few housekeeping items for today's presentation. We have ASL interpretation available for today's workshop. We also have live captioning services in English. It will be recorded in Spanish as well, so that will be available at a later time. And for the Spanish interpretation, right now our bridge line is not working, so we're hoping to be able to have that connected here. And if not, we will have that recording available for you as well. Okay. If you have, again, those services, you can, those needs, you can enable the CART services down at the bottom of your screen by clicking on captions, and you will have the captions that will pop up on your screen as well. You can also pin the interpreter if you needed to have them available. Okay. Any questions or comments, you can add them to the chat, and we will have time at the end of the presentation to answer any questions for you. And this presentation is also going to be available for later viewing on our YouTube, again, with those options for Spanish interpretation as well as English. And so please feel free to add any questions as they come up. All right. So we are going to keep moving here. I'm just moving over. I want to make sure to modifying my screen a little here. All right, so we're going to go ahead and move forward, and I am going to hand it over to Amanda. Amanda, if you could just give us a brief introduction of yourself and tell us a little bit about your role at the Arizona Center for Disability Law.
Yeah, absolutely. Thank you, Sonia, for having me. And thank you all for being here. As Sonia said, my name is Amanda Glass, and I am an attorney at the Arizona Center for Disability Law. My title at the center is Managing Attorney of our education team. So the Arizona Center for Disability Law provides legal services and advocacy support to people with disabilities in the state of Arizona in a variety of areas related to disability. So we work on disability discrimination issues in housing, employment, public accommodations, healthcare, and also in the area of education. So I manage our education team. We do work around provision of special education services to students who are in kindergarten through 12th grade. We also work on early intervention issues for kids 0 to 5. And then some higher education issues as well. So when students are in post-secondary, either in college or a trade school or even, some of the professional licensure issues like medical school or taking the bar exam if you're going to become an attorney, things like that. So when there's issues related to disability discrimination, we are available to provide resources, information, and in some cases, we do take on clients for direct representation as well. And so we are part of the protection and advocacy system. There is an agency like ours in every state and territory in the US that provides these free legal services. And we are created by an act of Congress at the federal level. So we are part of the federal budget every year, funds us. We've been pretty lucky to kind of maintain a steady level of funding over the last few decades. But it's unfortunately not enough for us to help every single person who calls us and is looking for representation. So because we just don't have enough staff or resources to provide legal representation to everyone who could use it, we do put a lot of effort as well into the creation of self-advocacy resources so that individuals can understand their rights and self-advocate. If they're not able to have an attorney to represent them, they can understand their rights and things they can do on their own to advocate for their rights to be met.
Wonderful. Always such a great need. As you know, there's so many different areas, with our families and our children who might have any level of disability, any special needs, any accommodations. And so I know here at the commission, we are definitely always partnering with ACDL, trying to make sure our families are getting this additional support. When we're not able to answer those questions, we definitely recommend them over to ACDL to get those more, the more legal support and all those other things. And so that's why it was important for us, to have this workshop at the end of the year as families are thinking of different things for the next year, really trying to make sure that parents have the tools and become those self-advocates that we want them to be for their children, and for themselves as well. And so we have a lot of parents who are deaf parents of hearing children and hearing parents of deaf children. And so really just understanding their rights as parents as well as the individual rights of their children. So we really appreciate you being here, Amanda. So we have a couple of questions in different areas that we wanted to cover here. And as things again come up, and if you have any questions, feel free to add those to the chat. So we know that oftentimes parents are offered a copy of their parental rights during IFSP meetings or IEP meetings, or any other educational or clinical setting. And we really want to talk about if that is not made available in their language or in an accessible format that they can understand, and an interpreter is not available in their native language, what would be your recommendation for parents in this type of situation?
Yeah, so that should never be the case. Procedural safeguards are one of the things that public schools and public charters are required to provide to parents in their native language. And that's in the statute, that's in the law. And I'm going to throw into the chat a link to the federal regulations that go over that, but I'll kind of explain it. So under IDEA, which is the Individuals with Disabilities Education Act, and that's the federal law where IEPs come from. So if your kiddo has an IEP, they are covered by IDEA. That law specifies a few different things that need to be provided to parents in their native language. I wish it included more things. Unfortunately, for example, the IEP itself doesn't necessarily have to be provided in a translated copy to parents. But they do have to make it understandable for parents. So that might mean including an interpreter in an IEP meeting and answering any questions the parents, a limited English proficient parent would have in their native language, using an interpreter or a written explanation in their native language. But there are certain types of documents within the special education process that the statute itself specifically says must be provided in the parent's native language, and procedural safeguards is one of them. So like you said, Sonia, the procedural safeguards notice has to be given out, again, by law at least once a year, but typically more often than that. In general, schools will provide this notice at every meeting that they have with the family. And there's some other specific times that it has to be provided by law, and that's laid out in the statute. But if you look at the regulations that I linked there in the chat, it specifically says that this notice has to be provided written in language understandable to the general public. So first of all, they're not supposed to be providing this information in legalese. It's supposed to be understandable, simplified language that makes sense. I'm not sure that it really is. I'm not sure all parents are able to understand it because it is very complex. And I think it could be made more understandable. And that's one of the things our office tries to do when we create self-advocacy resources, is we really strive to make things understandable so that anyone could pick it up, whether you're an attorney or not, and read through it and understand what your rights are, while at the same time retaining, the important meat of the information, not letting important nuances, be swept aside in favor of simplifying the language, but at the same time making it understandable, not using jargon or too many acronyms or terms that just wouldn't make sense if you're not immersed in this area all the time. The statute also requires that the notice be provided in the native language of the parent or other mode of communication used by the parent, unless it is clearly not feasible to do so. So for our deaf and hard of hearing parents, this may mean providing the notice in ASL, in a video ASL interpretation, or if they're not able to read written English, some type of interpretation that would allow them to fully understand their rights in that notice. And it actually says in the second part, if the native language or other mode of communication is not a written language, then the school must take steps to ensure that the notice is translated orally or by other means to the parent in his or her native language or mode of communication, that the parent understands the content of the notice, and that there's evidence that these two things have occurred. So it's actually in the law. So if you are a parent who's deaf or hard of hearing or speaks a language other than English, and you're being provided this notice of procedural safeguards, the notice of your rights relating to special education only in written English, and you can't understand what they say, that's a violation of the law. So my recommendation as an advocate would be to first approach the school, and whether that's going to your child's special education teacher, or if they have a case manager, going to the case manager, or you may want to go above those people's heads, because honestly, they may not be fully aware of what their obligations are. They're dealing with the day-to-day of educating your student. They may not be up to par when it comes to understanding the law. So I often, if you're struggling to get what you need from the school site administrators, I usually recommend that parents go to the district level. So most public schools, you've got your school site, but then you also have a larger school district. So especially the bigger districts have many, many schools within the district itself. But at the district level, there's usually a special education director or exceptional student services director. They have different titles, but essentially somebody who's in charge of special education for every school in the district. And if you can figure out who that person is, they might be the better person to go to if you're coming up against some barriers at the school site level with getting this notice in your native language. And I would ask them, I would let them know, hey, I'm deaf and hard of hearing, or I'm Spanish speaking, whatever it might be. I've asked the principal, or I've asked my child's special education teacher to provide all materials to me in my native language, and yet I'm continuing to get this notice in English only. Can I please get it in my language? And my number one suggestion as an attorney to all parents is put everything in writing. So don't just place a phone call with this request. I would put it in an email is usually good, because then you have a written record that when it was sent and who it was sent to. So put this request in an email to the special ed director for the district and kind of say, I am requesting that I get this notice in my native language as required by the law. And you can even cite to the law that I put in the chat there. And if you don't get the response you need, if they don't, immediately apologize and send it to you in the language that you need, then you do have the right to file a complaint with the State Department of Education. And I'll put a link to that in the chat as well. But this is a pretty black and white violation of federal law if the school is refusing to do this. And when you have violations like that, where the school is simply not following the letter of the law, there would really be nothing up for interpretation here. It's not a question of, is your child receiving an appropriate education, and what does appropriate mean? Those types of things can be a little more complex and may not be appropriate for the Arizona Department of Education to adjudicate. But for this, where it's really like the law says I should get this in my native language and the school is failing to provide it, that's something that is appropriate for the Arizona Department of Education to investigate and hopefully adjudicate in your favor. So I'm going to throw the online dispute resolution complaint form into this chat as well. There's an online form you can fill out and submit to the Department of Ed. And then they will assign an investigator. They are required by law to investigate allegations of violations of IDEA. So if you fill this out and submit it, and they will only look at things that have happened within the past year, calendar year. So you can't submit a complaint about something that happened more than a year ago. They won't investigate that. But as long as it happened within the past year and it's related to IDEA, they are required to investigate. And so in this specific instance, I would definitely think they would open an investigation. I think they would find in your favor, and they would probably order the school to immediately correct this, send you the notice in your native language. They might even order the school to train their staff so it doesn't happen again, revise their policies, reach out to their non-English speaking parents to give them some more information about their rights. So I would hope there'd be some pretty robust corrective action, because this would be a big problem if this is happening. But like I said, the tough thing about education law in general is that it's not something where, you can go file a complaint and everything gets better and it doesn't, you never have to talk to the school again because you got what you wanted. Like, this is sort of an ongoing relationship between you and the school, because hopefully your child is going to continue to attend the school. So you want to maintain an amicable relationship with the school district, right? You don't want to be really contentious and adversarial. So we always suggest that before you go filing complaints, even though you'd be well within your rights to just file this complaint right off the bat, we suggest, try to resolve it informally first. So reach out to that special education teacher, reach out to the special ed director for the district. It may be that they just, they're not fully aware of what's going on. So really let them know. And again, put it in writing, put it in an email. Here's everything that's happened. Here's why I'm upset. Here's what I want to make it better. And then give them a date. Say, if I don't hear from you in the next week, I'm going to look at filing a complaint. And you don't have to be threatening, but you can kind of say, I want to resolve this with you. Please let me know how we can fix this so that I don't have to file a complaint. But if they don't get back to you, you do have that right to file that complaint. So kind of in summary, if you are told that that you're only going to get this notice of your rights in written English, that's illegal. The school is required to provide it to you in your native language. If they fail to do so, you have the right to file a complaint with the State Department of Education. And I put a link to that complaint form in the chat.
Thank you for that, Amanda, and such a great explanation, because I know it can be one of those situations where parents just don't understand, what these safeguards are. And as you mentioned, they are lengthy documents. They come in this legal language that, many of us just don't use that language, right? And let alone our families who are, wanting to understand this educational process. So I appreciate that explanation of, those steps and what options are available. And thank you for those links. Those are wonderful. We will make sure those get posted to that as well for those who are not able to see that. As you provide those links, is there anywhere that you have on your website or any guidance documents that you would recommend specifically towards this procedural safeguards, Amanda? Is there somewhere these are housed or something that you can recommend?
Yes. So our office, like I said, we try to provide a lot of self-advocacy resources that are in understandable language for parents, and we also try to make them really accessible. So I won't say 100% of our resources are available in Spanish and in ES and ASL yet, but most of them are, and we're always working on looking at our older resources and trying to get them translated. So most of the education resources are available on our website in both Spanish and with an ASL video interpretation. So hopefully that makes them more accessible to parents. But we do a lot of blog posts on our website. So I'm going to post the link to one specifically about procedural safeguards. So our website in general, I think there's a lot of good stuff there. So I'll also post just the general link. So what I just posted in the chat is a blog post we have about the procedural safeguards notice, kind of breaking it down, what's included in that notice, why it's important to actually read it, what are the most important parts of the notice for you to be aware of as a parent of a student with a disability. But then just in general, and I don't think our website is the most self-explanatory right now. We're working on making it a little more user-friendly, but I'm going to post a link to our education rights landing page, which has a bunch of resources in English, Spanish, and ASL, like I said. Unfortunately, they're not super well organized right now, so they're kind of in a random order, I would say. But if you're willing to kind of use the search bar and scroll through some stuff, you may find some really good gems in there. I hope you would. So that second link there is just our website's general education landing page that's going to have a lot of different resources available. But if you're having trouble navigating the website, or you just are looking for a little more tailored help, you can always call our office and do an intake if you have a specific question or a specific issue. And I'm going to go ahead and just drop the contact us information into the chat as well. So you can do an online intake with our office. We have an online fillable form as well, or you can call us and then you'll get a call back from an intake advocate who can help you complete an intake. And everyone who calls, whether we're able to assign you an attorney or an advocate to provide direct services to you or not, if you call us, you're going to get some kind of assistance. We help everyone who calls us. So it may be sort of a tailored list of some self-help resources. So, if you're struggling to navigate our website and you just want someone to kind of send you the right resources for your issue, you could call us and talk with an intake advocate who will then direct you to the appropriate resources relevant to your issue and in your native language. So that's kind of what those three links are in the chat. The first one is a blog post about procedural safeguards. The second one is the landing page for all of our education rights resources. And then the third one is has the contact information to complete an intake with our office.
Wonderful. And I know that I am on that website quite a bit. So I appreciate you helping navigate that a little, because there's so much information there for families that you can often get, lost in one thing because you see such great information on one and then you're really looking for something else. So I appreciate you definitely giving us that guidance and how it's kind of broken down in the different blogs that are available.
For sure.
All right, wonderful. So we'll keep moving here. Some other things that I just want to make sure to address are things that we often get here at the commission. Again, when parents are concerned about their child's progress, if a child's not making progress as a parent thinks they should, or maybe they just see some regression or just some concern, and they'd like to request additional evaluations for their child. What are some of the options for parents under 3 in that pre-K stage, and then of that school age that are required to be offered in our state?
Yeah, so when we think about kids and the services they get, I think we often divide them into those 3 categories that you just laid out, sort of the 0 to 3, and then the pre-K 3 to 5, and then the school aged being 5 through 22. But actually the way the law treats kiddos is just dividing them into 2 groups. So it's the 0 to 3, and then 3 to 22 is actually the second group. And the only reason that's an important distinction is because it impacts where you go to ask for that additional help, and which agencies are responsible for serving kids in those 2 different age groups. So kids 0 to 3 are covered by IDEA, that law I mentioned earlier, the Individuals with Disabilities Education Act, Part C. So Part C kiddos are the early intervention 0 to 3. And then 3 all the way up through 22 are covered by IDEA Part B. So going back to early intervention, the littles 0 to 3, IDEA Part C, they are entitled to early intervention services. And again, IDEA is a federal law. So what it says at the federal national level is that each state has to designate an agency to provide early intervention services. In Arizona, we kind of created our own. It's called AZIP, the Arizona Early Intervention Program. And it's sort of a shared responsibility between the Department of Health Services and DDD, the Division of Developmental Disabilities. And so they work together from a funding perspective to fund AZIP. AZIP is the program that's going to be identifying and serving our littlest kids, 0 to 3, who have disabilities. So if your kiddo qualifies for early intervention, they should have, like you mentioned, Sonia, an IFSP, an individualized family service plan, where they're getting services that are not school based. They're based in your home. They're not really academic, because kids 0 to 3 are not really reading, writing, and doing math yet. It's going to be more about the developmental milestones that perhaps they're missing. So they may be getting things like speech therapy, feeding therapy, occupational therapy. Those are the more typical early intervention types of services you're going to see. And AZIP doesn't provide, they do provide some direct services, but a lot of it is going to be more about training the family on how to work with kids in the home. So that's why it's called a family service plan. They're going to be doing a lot of teaching the parents, these are the activities you should be working on with your little one at home. And then, they will check in and measure progress, and you will have those regular IFSP meetings where you're setting goals and discussing services and things like that. For those younger kids, if you have concerns, if you think your child may need a service that they're not currently getting, or they're not making the progress that you would expect them to be making, and you just want them evaluated again, you're going to submit your request for a reevaluation to AZIP, and that's the responsible agency. So you could submit that request directly to, if you have a case manager from AZIP, you could submit it to them. If you need to reach out to someone higher up at AZIP, you could go to the AZIP website and look for, a regional contact who might be able to help you. But essentially, again, my suggestion is always to put your requests in writing. So put it in writing. I'm requesting my child be evaluated in the following areas or for consideration for the following service. So let's say your kid has been getting physical therapy and occupational therapy, but now you're concerned about their speech language development. So you could say, I agree that they should continue to receive the services that they're already getting, but I would like them to be evaluated in the area of speech language for consideration of that service as well. So put it in writing, submit it. Upon receipt of your request for an evaluation, AZIP has to reply to you in a timely fashion and let you know, if they're going to move forward with an evaluation or not. They do have discretion to kind of decide whether they suspect a disability in that area. If they have no reason to suspect, they may refuse to do the evaluation. But if they're going to refuse, they have to put it in writing. So they have to submit something to you called a prior written notice, detailing their refusal and why they refused and what data they considered in making that decision. But typically, I think if you request that evaluation, they're going to go ahead and agree to do it. They'll get your consent as the parent to move forward with that evaluation. And then they have 60 calendar days to conduct the evaluation and get you the results. And the results would be discussed with you in an IFSP meeting. And it's going to be largely the same for that second group of 3 to 22-year-olds, except instead of sending your request to AZIP or to a separate agency, you'll be sending it to the school district. So for kids 3 to 22, the agency responsible for evaluating and providing services is the school district of enrollment. Or if the child is not enrolled, it would be the school district of residence. So same thing, you're going to submit your request for an evaluation. Again, I recommend you do it in writing. And you can do it to the case manager, or if you want to go above their head, go straight to the special ed director for the district and say, I'm requesting an evaluation for my child in XYZ area. And honestly, when you request a reevaluation, you don't have to say why. And there's no legal requirement that you justify why you're requesting it. But I think it can be helpful to do so, to kind of say, I've seen their grades are slipping in math, or I think they're really struggling with they're really struggling socially. They don't have a lot of peer relationships that they're able to maintain. And that just kind of helps the school determine which tests would be most appropriate to administer to gather that new information. And so same thing, the IEP team will determine if they're going to move forward with the evaluation. They'll get your written consent to do so. And then from the time they receive your consent, they have 60 calendar days to conduct that evaluation and come back together to discuss, whether the child may be eligible under a different category and whether they should receive additional or different services in order to provide a free and appropriate public education to them.
Thank you for that. Such great information, things that I'm writing down as well. That again, making sure that we understand those deadlines in the 60-day time frame and things like that are so important for parents to know, because oftentimes that's not always provided to them, right? And it's one of those things that might be that fine print that's so important to know how long you have to wait if you don't receive a response from the school. How long should you give them before you follow up with a phone call? So thank you for giving those timeframes. So helpful in helping us understand what the different options are for parents. Mm-hmm. Let's see, another area that we really have a lot of calls about as well is that assistive technology. So we know that as advancement in technology, continue to improve, things are just getting really, really, helpful in certain ways. There's a lot of assistive technology that's offered to families for use of the equipment in their educational settings, but not necessarily in the home. And so what we get a lot is, if a family is denied the use of the assistive technology in their natural environment, if they wanted to take something home that the child was utilizing in the educational setting, or they made that request to the program or the school, and it was denied, to use in a childcare center or in the home or whatever that child's natural environment may be, what would you recommend if the child needs it for extracurricular activities, or again, needs it outside of that classroom setting?
Yeah, so AT is definitely part of the IEP. So there are regulations and statutes within IDEA that specifically talk about assistive technology and what is covered or what needs to be covered by the school, and what doesn't. So I'll kind of talk through some of that so that there's some understanding there. So IDEA itself does define assistive technology. It specifically states that schools have to use assistive technology devices and services to maximize accessibility for children with disabilities. So one thing to consider is that IDEA does include, under the concept of an evaluation for special education services, AT is a type of evaluation that can be conducted. So if you're not sure if your child would benefit from a specific piece of assistive technology or from any kind of assistive technology in general, that's something you could request that the school do. So again, put it in writing, but I would submit a request to the school district for an AT evaluation for your child. And that way the school will actually conduct that evaluation and determine whether AT is needed for your child to benefit from their schooling and receive a free and appropriate public education, or not. And if they do require AT, to help determine what type of AT service or piece of technology or equipment is most appropriate for them. IDEA, again, it defines both assistive technology device and assistive technology service. So an assistive technology device is any item, piece of equipment, or product system, whether acquired commercially off the shelf, modified, or customized, that is used to increase, maintain, or improve functional capabilities of a child with a disability. And the definition from the law of assistive technology service is any service that directly assists a child with a disability in the selection, acquisition, or use of an assistive technology device. So examples of services that could be put into an IEP related to AT could be, first of all, the evaluation, but also the purchasing, leasing, or otherwise acquiring assistive technology. And then it could be things like selecting, designing, fitting, customizing, adapting, applying, maintaining, repairing, or replacing that specific piece of technology. It could also be coordinating and using that AT with other therapies, interventions, or services. It could be the training or technical assistance for the child or the family of the child in how to use that AT. And then it could also involve the training or technical assistance for other professionals so that they understand how to effectively use the AT when working with the child. There is a very specific exception in the statute when it comes to AT. For a child with a surgically implanted medical device, the school is not responsible for maintenance, programming, or replacement of that device or of any external component of that device. So the thing that comes to mind typically is a cochlear implant or something similar. So that's going to be something that your child's medical provider and, possibly in medical insurance access would have to be responsible for. It's not something that the school is going to pay for or maintain. However, there is an exception to the exception that the school does need to ensure that the external component of the surgically implanted medical device is functioning properly. They may not be required to replace it or repair it, but they should be checking that it's working as needed for that child. So if it is determined that a child requires assistive technology in order to receive a free and appropriate public education, there should be information about that assistive technology included in the IEP document itself. If the child is going to need services, like any of the things I mentioned about maintenance or repair of the device, or training for the child or the family or other teachers about how to use the device, all of that should also be documented in the IEP. The school is required to provide the AT specifically when it's needed for the student to benefit from their special education services or related services. And then to get to your question about, well, what if my child could benefit from that technology outside of school? Is the school responsible for that? Essentially, what the law says is that school purchased assistive technology can be made available in the child's home or in other settings if the IEP determines that the child needs that assistive technology to receive a free and appropriate public education in those other settings. So something purchased by the school really needs to be advancing the child's education in order for it to be used outside of school. So, if you think about like an augmented communication device, that might be necessary for the child in school so they can communicate with their peers and their teachers as they're learning. And it could also be necessary for them to use outside of school when they're working on homework or engaging in extracurriculars related to their education. And unfortunately, it's kind of subjective. It's not something where it's black and white, like anything that a kid needs at school, they also need throughout the rest of the day. And because it's not quite that clear in the law, it ends up being an IEP team decision about whether it's needed outside of the school setting or not. So in terms of self-advocacy, if you want your kiddo to have access to this assistive technology outside of school, you really need to kind of think through ahead of time arguments for how using this technology outside of the school day really is needed for your child to benefit when they're at school. How is it necessary for them to get a free and appropriate public education, or FAPE, as we call it, using our acronym? So I would kind of, think through it, talk with, family and your child, and come up with some arguments that you could bring to the IEP team meeting about why this is important for the kiddo to have, not just during the school day, but, after school and on the weekends as well. They're practicing using it so that they're more fluent with it in the school setting. They're more efficient. They're able to get more done and communicate more clearly and quickly if it's a communication device. Obviously, if it's something else, you're going to come up with the most appropriate evidence. The skills that they're picking up outside of school when they're using this device are applicable when they go into school. They need it to do homework outside of school, or they need it, if their IEP has a goal related to improving peer interaction, they're going to need to practice that outside of school as well. So allowing them to have this assistive technology outside of school will help advance their progress toward their IEP goals when they're in school. So just kind of think through, in what ways is it important for my child to have this AT outside of school? How is having it outside of school going to benefit them when they're in school? And that's really what the IEP team needs to decide. Is it necessary for the kiddo to have it outside of the school setting in order to receive FAPE when they're at school? And it may also become a question of, who funds this, right? So sometimes devices are funded by the school directly. Sometimes the school will argue, well, this is something Access should be covering or DDD should be covering if your child has DDD. That can be an argument that these different agencies have with each other, but your child shouldn't be without a needed device in the meantime. It's really you could kind of argue, my child should not suffer or be deprived of something that they need, while you argue with other agencies about who's responsible for funding it. At the end of the day, if they need it for FAPE, for free and appropriate public education, the school has an independent responsibility to make sure they have it. So if the school needs to fund it while they, file for reimbursement with Medicaid, or otherwise arguing about who's going to pay for a repair, let them have that argument, but your child should get what they need in the meantime. So, my big tips are gather evidence, try to think through an argument of why they need it outside of school in order to advance their learning in school. Again, put everything in writing. So kind of document as much as you can, all the requests you're making. And if you are being denied something you think that your child needs, you can always call my office. Again, we have a lot of information about self-advocacy resources, options that you have, like to go to mediation if you need to, or request an independent AT evaluation if you need a second opinion about why your child might need AT. And we can get you that information if you reach to us and do an intake with our office.
Thank you. Lots of information and just so much more, that we, again, individualized, right? So for every family, their needs are going to be different, and really just understanding the big scope of things, right? And really what can they request and what is feasible. But I think those tips, Amanda, that you're giving, just to really think about why your child would benefit from these things in other settings, and how it could be more of an explanation as you're requesting these additional services, really, really helpful to supporting what your child's needs are. So I appreciate that. And then again, Amanda, do you guys have links to any assistive technology information on your website, or anything that's available in that section as well that kind of helps with this? Guidance documents or anything like that?
Yeah, absolutely. Let me put a link again in the chat. Yes, we have a lot of information about AT on our website. Not necessarily specific to the education setting, but just assistive technology in general. We have some self-advocacy guides. I'll put the landing page in the chat so that you all can access it at any point. But yeah, I mean, that is definitely something that we do a lot of work in that area. Excuse me. And we present, there's an assistive technology conference that takes place, I think, annually in Phoenix, well, I guess for all of Arizona. And so we often present there as well. That's a really great place to get more information. Also, the Assistive Technology Conference. But yeah, we've got information on our website, and that's the landing page for our self-advocacy guides right there in the chat.
Wonderful. Thank you. I know we've got a few questions here coming up, but one last thing that I really want to ask is, if there is one important recommendation that maybe we haven't covered today. I know we try to really think of the areas that we at the commission receive on an ongoing basis and the trends that we see. But is there one important recommendation that you could share with parents who are advocating for their children who might be deaf or hard of hearing or deafblind in the educational settings? I know we deal with, all settings, but if we're talking more specifically about the educational settings, what is one thing that you can share with our parents for those specific purposes?
Yeah, for sure. So again, I'm a lawyer, so I'm coming at it from a legal perspective. And I think for that reason, I think about people's rights in terms of the laws that exist. So most of what we've been talking about today is IDEA, which again is that federal law where IEPs come from. And there are some really good specific rights that come to parents and students with disabilities through IDEA. And I talked a little bit about some of your options if a school is violating IDEA, including filing that complaint with the Department of Education. But people with disabilities are also covered by some other civil rights laws. Two of the other big ones are Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. So those are two other federal laws. Neither of them is specific to education. They apply in other settings as well, but they do apply to schools. So it's kind of important to be aware not only of IDEA and your rights under that law, but also of students' rights under 504 and the ADA. I'm going to share in the chat again one more link. This is to the US Department of Education's Office for Civil Rights. So again, at the federal level, we've got the US Department of Education. They have several programs under them that they administer. One of them is their Office for Civil Rights, and the Office for Civil Rights enforces various civil rights laws, including Title VI of the Civil Rights Act, which prohibits discrimination on the basis of race or national origin, Title IX, which prohibits discrimination on the basis of sex and gender, but it also does enforce Section 504 and the ADA, which are those other two laws I just mentioned. This link will take you to a guidance document from the US Department of Ed's Office for Civil Rights, specifically about the right that students have to effective communication in school. So this kind of goes over, and there's obviously a lot of overlap between IDEA and 504 and ADA. All of it essentially at the meat of it is if you have a disability that impacts your hearing or you're deaf or hard of hearing, then you should be provided equal access to education. Like that's the meat of all of the laws. But the way the laws are written is slightly different in each one, and the options for complaining essentially are different under each one as well. And it's good to kind of know about your different rights for filing grievances or seeking some kind of remedy or redress if your rights are being violated. So I went over the state complaint. I gave you the link for how to file that complaint with the State Department of Ed. But I wanted to just touch on this as well before we go to questions from attendees, because you can also file a complaint with the Federal Office for Civil Rights if you feel like your child or your rights are being violated under the ADA or 504. And essentially, this document is helpful because I think it kind of compares and contrasts your rights under IDEA versus ADA and 504. And it actually says, IDEA might say you're only entitled to whatever you need to get a free and appropriate public education. You're not entitled to a Rolls-Royce education. You're entitled to a Chevy education. And that might mean if you're deaf and hard of hearing, if you can gather, what's going on about 70% of the time using just an FM system, that might be all that we have to provide you under IDEA. But if you could be getting 100% of what's going on, if we provided you with ASL interpretation in addition to an FM system, that would be much more effective communication, but you might not be entitled to it under IDEA alone. But ADA and 504 are actually a little bit stronger. These laws entitle you to a little bit more than IDEA does in terms of effective communication. And so that's why I think it's important to not just know about IDEA, but also ADA and 504, because you might think, my kid can do okay with FM. They're getting B's and C's, but if they had an ASL interpreter, I'm sure they could be excelling at school and getting A's in all subjects. And I really think they would do better. They do okay with FM. They hear enough to benefit from that, but their first language and their most, their native language is ASL. And that's what they need to actually fully access and get effective communication. And if that's the case, you may be better suited pursuing a remedy under 504 and ADA, because those laws entitle you to a bit more than IDEA does in terms of communication. So this document I linked, I think, is really helpful in kind of explaining what I tried to just summarize in a nutshell. It gives you a little more detail. And then ultimately, if the school is not doing what you need them to do, you do have the option to file a complaint with the Office for Civil Rights, and they can investigate and order some type of corrective action if necessary. So that was the last tidbit I wanted to share, is that, you know, you have rights not just under IDEA, but also these other two laws, ADA and 504.
Perfect. Thank you for touching on that. And that's exactly where I was hoping you'd be able to go with that. There's just so much information that, you know, we're always wanting to share with families, but it's also such a, you know, a heavy topic. And so helping families and parents understand each, you know, the different areas is can be complex. So I appreciate how you're breaking it all down and just really putting those things in just those family friendly ways, and making sure families understand things. One thing that I wanted to ask you, Amanda, before we open up to questions is, can you tell me a little bit about how we talk about legalese, and we know, being in this legal world and this, you know, advocate, there is appropriate versus effective.
Yeah.
Can you touch just a little bit on that? Because I know that's one thing that I'm always having those conversations with families about as well.
Yeah, I'll do my best. So appropriate is, I think it kind of depends on the context you're using these words in, but appropriate in the context of the phrase free and appropriate public education, essentially that phrase is a standard under IDEA that is not well defined, but it's defined in IDEA itself. So the statute kind of lays out what a free and appropriate public education is. And the appropriate part of it, this has actually gone to the Supreme Court a few times. One time in the 70s was a case called Rowley that was actually about a deaf and hard of hearing student. And that it's sort of the example I was giving about FM versus ASL interpretation is essentially the Rowley case. And what, unfortunately, the Supreme Court held at that time was that child, you know, had a really high IQ, could have been getting 100% in every class if they'd provided her with an ASL interpreter, but they weren't. They were providing her just with that FM system. And with the FM system, she did okay, but she wasn't excelling. And essentially, the Supreme Court said that's okay. That's allowable under IDEA. An appropriate education is one that lets you access the learning, but not necessarily one that lets you excel or that maximizes your potential. It's just enough to give you that kind of bare minimum access level. And that was the standard for a long time until 2017. So fairly recently, there was another Supreme Court case that kind of challenged that standard under Rowley. And that case was called Andrew F. And it wasn't about a deaf kid, it was about a student with autism. So a different set of facts. But the question again was, what does it mean to be provided a free and appropriate public education? What is appropriate? And certain courts had kind of held that all you need is a de minimis benefit in order to meet that standard. And de minimis essentially means minimum, like the very bare minimum. What's the bare minimum we can give this kid so that they can access an education? Other courts in other parts of the country had sort of generated their own slightly higher standard. But what the Supreme Court held was that this de minimis standard was too low. We can't, an appropriate education is not one that minimally lets you access school. It has to be a little bit more than that. And so the new standard, and I know you said, you know, legalese, this doesn't make sense. Unfortunately, this is what we have from the court. So the standard now under the new Supreme Court decision, Andrew, is that a free and appropriate public education is one that allows a child to make meaningful progress in light of their circumstances. Which again, what does that mean? It's just essentially more words. It still feels, to me at least, very subjective. The reason the court left it super subjective is because they feel like it's an individualized decision, that it all needs to take into account the facts of the individual student's case. Every kid is different. We don't want to set, you know, a base standard that all kids have to earn at least a C+ in order for us to consider them, you know, getting a free and appropriate public education, because what is a C+, you know, so there is a lot of subjectivity still. Essentially, if you as a parent don't think your child is getting a free and appropriate public education, you don't think that they are being given services that allow them to make meaningful progress in light of their circumstances, you have the right to go before a hearing officer, or in Arizona, an administrative law judge, and present the facts as you see them. I don't believe my child is being afforded a free and appropriate public education. Here's why, here's how they're performing, here's how they've regressed compared to their peers. If they were given this other service, I think they would make this progress based on this research or this outside evaluation I had done, whatever evidence you gathered. And then a judge can weigh the evidence that you as a parent provide and the evidence that the school might provide to make a decision about whether the child is getting that appropriate education. So that's appropriate in that context. Effective is usually, for effective communication, and that phrase, again, is typically, that's used more in 504 and ADA. So effective communication, in this document that I linked talks about it a little bit. It's not just about, what does the child need in order to sort of be able to understand or sort of access the learning. It's really about what does the child need to, it's not maximize necessarily, but it is a higher standard than the appropriate one. So if you look through that document, it really talks more about the rights that you have to effective communication under these other laws. And effective communication includes not just being given the support or the interpretation you need to sort of understand, but it's being given what you need that's in part, it takes into account your preference, which is different from IDEA. So it does kind of say, if your child could equally benefit from ASL as they could from closed captioning, but your child prefers ASL, they have to actually take into account that preference. And so for effective communication, it involves your preference, either your child's preference, or if you're deciding for them as their parent, your preference. So that's one important piece of it, is that it's not just about, how could they understand, but how would you prefer they understand? So in general, I think the effective word, at least as it's used under ADA and 504, is actually a stronger right for families than the appropriate term is under IDEA, at least in terms of communication. It's a little different for other areas of special ed, but for communication, the effective communication phrase from IDEA or from ADA and 504 is stronger than the appropriate phrase from IDEA. I hope that helps.
Yes, thank you for that.
Mm-hmm.
So helpful. Okay, let's go ahead. We've covered some great information, and I want to make sure that we allot some time for our participants to ask questions. So if you have any questions at this point, feel free to utilize the little raise hand option. If you are down at the bottom of your screen, you can see the reactions, and you can just choose this, select the raise hand option. If you have a question or a comment, once we see that little raise hand, we'll call on you, and you can choose to come on screen, or you can just put it in the chat if you'd like. But we want to give you the opportunity to ask your questions at this time. There we go. I see Jesus on my end. Okay, Jesus, would you like to turn your screen on? You can lower your hand as well.
Apologies, the interpreter wasn't ready for interpreting into English. Go ahead, Jesus. This is Jesus speaking. I wasn't sure if I should keep my camera off or just type my question. But I figured I would wait to the end, Sonia, like you told me to. I wasn't sure if I should interrupt the presentation. So Sonia has been working with us for a long time. I have connections with ACDL as well. And I would really like to learn more about the rights that my daughter has, specifically in school. She was going to a deaf school. Hang on one moment. She was going through a deaf school in California, and we had her IEP goals set through that school. When we moved here, though, there was some issue with who should be paying for things like the interpreting services that she needs. Now, she is very adept at self-advocacy, which is wonderful. And that's what we saw at the school in California. But here, since she's moved to this school, we've had some issues with that. We're not exactly sure where to go. I know that, Amanda, you had talked about the 504 and information about the 504 and the ADA. That was great information. But we seem to still be getting a runaround from the district. We don't know exactly who makes the final decision about these kinds of services, who approves or denies these services. And it seems that when we have a meeting, the person who has the ultimate decision isn't a part of those meetings. So we're just not sure where to go.
Yeah, so there's a couple things I got from that I can talk through. And I do know that you are working with another attorney in our office. So I don't want to speak too much to the personal, the personal facts of your case, but I think generally, you brought up some good points that would be beneficial for others. So, one is moving from one state to another. So, IDEA is a federal law. It applies in all states that take money from the federal government. The Federal Department of Education have to follow IDEA, but states can then add additional requirements at the state level to what they're providing to students. And some states choose to kind of augment what the feds are requiring to make it more robust. And other states do not. And Arizona generally is one of those states that kind of does the minimum of what they have to do at the federal level. California, I think, probably does a little bit more than what they're minimally required to do by the feds. So you may have seen some changes, coming from one state to another in that way. In terms of who is providing services, that's an IEP team decision. So if, for example, in a previous IEP, your child was receiving interpretation from a certificated ASL interpreter, and then you have an IEP meeting. Sorry.
So if I can ask, what's the specific position of the person who makes that decision? Is it an educator? Is it an administrator? Who does that?
So yes, I want to answer that as well. So technically, every IEP team has to include, and I'll find the statute and put it in the chat so you can have it. But every time the IEP team meets, there are certain members who have to be part of that meeting. And one of them is supposed to be an administrator or somebody from the school who has the authority to commit resources to a student. So that person should be in the meeting with you. And if they're not, that's a problem.
I mean, what's their name?
It depends. I mean, it depends on what who the district puts that power into, and different districts might do it differently. So for some, they may say, you know, the special ed teacher has the authority to commit to this. Some schools will say it's the principal. Some schools might say it's the special ed director for the whole district. If you're in doubt, you know, that your IEP team is complete, or that, you know, you have the right members there, I would reach out to the special ed director for the whole district, because that person very likely has the authority. And if they don't, they'll go to the superintendent, you know, to ask permission. But it's usually kind of the highest person in the hierarchy is going to be the special ed director for the district.
Okay, yes, I will have to do that, because I think that whoever that person is does need to be brought into our meetings. They haven't been. It's been several weeks. And even when I make a request, I can wait quite a long time. And the responses that I get don't seem to really address what we're needing. I've also asked for our meetings to be recorded, and I thought that was my right. Because I want to make sure that that the school district is providing us exactly what we need, but we're really being dismissed quite a bit.
Yeah, so my recommendation would be to try to invite the special education director for the district to your meetings, because they are the person who will have the best understanding of the district's resources and programming, and be able to, they'll be vested with that authority to make final decisions about what can or can't be provided to your child. And I'll put the IEP team member definitions from the statute. I'll throw that in the chat right now as well. So what it says is a representative. Yeah, a representative who.
I want to know how to better like support myself and my daughter through this process. So, and through the IEP process as well.
For sure. So I'm going to.
I know sometimes it's easy if you have children that are hearing or have a disability. It seems like they don't have issues getting services, but their voice might be somewhat suppressed as well in those situations. And it's really unfortunate, because as parents, you know, we have to be explained what an IEP is, what the process looks like, what we need to go through in order to get the correct services for our child.
Right. Absolutely. So the link I just put in the chat is to the regulations for IDEA, and it talks about the IEP team and who needs to be included. So, you know, the parents, a regular ed teacher, a special ed teacher, and then number 4 on this list is a representative from the public agency who, and then it lists a couple things. And then the third thing is knowledgeable about the availability of resources of the public agency. So essentially there should be a team member who knows what resources exist and can, you know, make that final decision about agreeing to provide certain services or accommodations. So that's, sorry, my dog's barking in the background. I hope you can't hear her. So that's what should be happening. You know, there should be somebody from probably the district at those IEP meetings, especially if you're asking for something that the school doesn't have readily available.
Right, and I did.
Okay.
Unfortunately, we've been going through this for 4 years.
Okay. Yeah. I mean,
thank you. I appreciate you allowing me to ask a question, but I'll go off now if we're good. That way I'll allow opportunity for anybody else to ask.
Yeah, absolutely. Thank you for your question and participating.
No problem.
Thank you so much, Jesus. Always great questions, you know, for others to hear as well. Just such a great opportunity for other parents who might have the same questions and not really know what to do. So I appreciate that explanation, Amanda. I've got another question that came through on the chat. Is it a school's obligation to tell parents of deaf and hard of hearing kids that they have the right to request a certified ASL interpreter for their child in the school? And if so, are schools doing this that we know of?
It's a good question. I don't know that schools are required to tell parents they can request a certified ASL interpreter. What schools are required to do is provide a copy of that procedural safeguards notice in the parent's native language. And that procedural safeguards notice goes over a bunch of rights to things like IEP meetings, prior written notices, the right to an independent educational evaluation. And it does, the procedural safeguards notice itself does talk about language access. But I think, I don't think there is a blanket right to a certified ASL interpreter. What there is a right to under the law, again, for IDEA, there's a right to a free and appropriate public education. So if a child needs a certified ASL interpreter to receive a free and appropriate public education, then that's kind of, a fact-based decision that the IEP team is going to look at the facts for this child and determine, do they need that to get that appropriate education? And then there's a separate right to effective communication under 504 and the ADA. Again, that's, I think, a slightly stronger right. And so that would be maybe the more effective route to go is to argue they need a certified interpreter to get effective communication under these laws. But the school, in terms of giving parents notice, they're required to provide that procedural safeguards notice, which is about IDEA. They should have some kind of ADA or 504 coordinator or office, and that is required as well. But giving parents specific notice of the existence of that person or that office, I don't think is required, other than having it publicly available, like through the website. I don't think they need to be sending letters home or talking to parents about their right to request that. It's really, and I wish it was, I wish there was a requirement that every school district sat parents down at the beginning of every year and told them in plain language and in their native language what their rights are. But that's not really what the statute says. It kind of says you get that packet of procedural safeguards, and if you have an issue, you can look up our ADA or our 504 coordinator and talk to them. But yeah, I don't think it's under the statutes, as far as I know. I don't think there's a requirement for schools to tell parents their children are entitled to a licensed ASL interpreter. At least not under those three laws, IDEA, ADA, and 504.
That is helpful. Thank you for that clarification. Another question that I have that came through. Are interpreters available for parents during the intake process if they were to contact your office?
Yeah, great question. So yes, we, so when you contact our office, I think I put that in the chat as well, the link. So you could call us, and we do use video relay services, or you can fill out an online written web intake form, and then we will set up an appointment with you, and we will use an interpreter, of your choosing. If you'd rather use, a communication device you have, or if you want us to get an interpreter for video relay, we can do that. But yes, we do try to accommodate everybody's requests around effective communication. We'll probably set it up as an appointment. We may not have someone available immediately when you make the first phone call, but we'll coordinate with you a good time, and we'll get an interpreter hired and ready so that we can have an effective conversation with you to gather that data and do an intake. And then if your case is assigned to an advocate or an interpreter, an advocate or an attorney for additional direct services, that person will then ensure that there's interpretation for every conversation you have with them about the case going forward as well.
Great. Thank you for that. I have one last question here. Do parents have to qualify for your program? If so, what would be one of the reasons that they do not qualify?
So the Arizona Center for Disability Law, we take cases. I mean, like I said, if you call us, you'll always get some level of service, at least some resources and self-advocacy information. In order to be assigned to an advocate or an attorney for additional assistance, we look at a few different factors. We have priorities that are set by our board of directors with input from the general public on an annual basis. And those priorities are actually, and I can put a link again in the chat, those are publicly available on our website. So you can kind of see what we are prioritizing in terms of what cases we're going to take. And mostly it's about, trying to protect the rights of those who are most vulnerable from abuse and neglect. And also ensuring access is a big one, and home and community-based services. So, but you can kind of look through our priorities under each of our different grant areas to see where we're prioritizing providing services. You have to be an Arizona resident. We don't help people in other states only because there are other protection and advocacy agencies for those other states. So we would just refer you to that appropriate agency in your state if you're not in Arizona. But other than that, we don't really have, as long as it fits within our priorities and you live in Arizona and you're not otherwise represented, we don't typically take on cases if you already have an attorney or an advocate working on that issue. But as long as, those things are in place, we don't have any kind of income requirement. We don't ask any questions about income level. So we're not like community legal services in that way. We help anybody regardless of income. Nothing about, race or religion or disability. We're completely, we don't ask questions about that, or if we do, it's just to collect data on the populations we're serving, but we don't discriminate in any way based on any of those factors. So as long as you have a disability, you live in Arizona, and your issue is related to your disability and fits within our priority areas, and you're not already represented, we're really open to taking anyone. We have no other disqualifying factors that we consider.
Thank you, Amanda. This is such great information. I'm looking here. Just want to make sure I didn't miss anyone. I don't see any other hand raised. I'm just going through my chat as well, making sure I didn't forget anyone. I think we are good. Wonderful. This has been such a wonderful and informative session. I appreciate what you do on a daily basis. I know I am always connecting with you as well when we run into those situations where I just need your additional support. So I appreciate all of this. We will have this available for families later on so they can access it as well. But I just want to say thank you so much for going through all of this, and have a wonderful day and a wonderful holiday coming up as well. So thank you again, Amanda. I appreciate it.
Absolutely. Thank you all.
Thank you.